reason we chose this particular date to have this panel is because a week from today, April 15th, the Supreme Court is scheduled to decide whether they are going to take this case. And Ed Whalen, who's on our panel, and he recently wrote a piece over at National Review for Bench Memos, and he says that this is the most important free exercise case in decades. So there's a lot at stake here. But I'm not going to talk any more about that. I'm going to talk about Mark, our wonderful moderator here. Mark is from the Weekly Standard. He's a senior writer there. He has written for the Wall Street Journal, MTV.com, Reason, and numerous other publications. Prior to joining the Weekly Standard, he worked at the Washington Examiner, National Review, Market News International, and USA Today. He has appeared on C-SPAN's Washington Journal, CNN, MSNBC, Fox News, and National Public Radio's All Things Considered. He was the recipient of a Gold Award Journalism Fellowship from the Phillips Foundation in 2003 and was a Global Prosperity Initiative Fellow at the Mercatus Center at George Mason University in 2003 and 2004. I'd also like to point out that his wife Molly is here with us today, and their two wonderful children. And if you know anything about Molly and Mark, they're kind of a power couple in Washington, D.C. I kind of say, I want to be like them when I grow up. You have Molly from The Federalist, who, if you turn on the TV, you'll probably see her every day. And then you have Mark all the time there as well. So let us, if you can join me in welcoming Mark Hemingway.
Sorry, let me get ready here. I apologize. First of all, thank you all for coming here today. I cannot stress enough how important the issues at stake are with religious liberty. One of the travesties of the past number of years here as religious liberty battles have become a little more prominent is how poorly they have been explained and how little ordinary Americans, I think, understand what is at stake. Our most cherished values of free expression in this country are dependent on something that are dependent on the truth. And there are two ways to get at the truth. You know, either we can strike some sort of balance where everyone among us is allowed the freedom to decide and discern for ourselves what is the truth and work together on that shared understanding, or we can have the quote-unquote truth enforced by some top-down consensus legally. And I don't think that when you look at those two scenarios, and given that the stark choice there, that it's much of a question which alternative is preferable. And I further don't think that people realize that there's an entire system of legal precedents and governmental infrastructure in this country that's rapidly being created to enforce this quote-unquote truth as it is determined by, you know, government officials, unelected bureaucrats, judges, you know, people that don't necessarily have that don't always have a perspective, I think, that is helpful or serves the majority of Americans. It's a lot of people with narrow, singular political agendas, trying to enforce some sort of, you know, cultural vision that they have that other people in this country obviously do not share. So again, I am honored to be here, and I hope that we can do some things today to better that understanding and make people understand what is truly at stake, and that there are real painful human costs to what they are trying to do in Washington State and other places. So with that in mind, I'm going to go ahead and introduce our distinguished panel. The first person to my right here is Kristen Waggoner, Esquire. I always like adding that little. She is the Senior Counsel and Vice President of Legal Advocacy with the Alliance Defending Freedom, where she leads the organization's legal and media efforts. Waggoner joined ADF in 2013 and has supported thousands of attorneys across the country on religious freedom issues. She's done lots of training for ADF and allied organizations on these issues, and has also done legal support on you know, all aspects of religious freedom, be it life issues, marriage issues, and other, you know, family and church-related issues and church religious issues. Waggoner was previously an attorney at Ellis, Lee, and McKinstry, where she was promoted to partner. She participated as counsel and prevailed in several high-profile constitutional cases, including Anderson versus King County, which was a same-sex marriage case, Stormans versus Selecki, and State v. Hamlin, which was an important case involving clergy penitent privilege. And I'd like to thank Kristen Wagner for being here today to help us. And next to Kristen is Ed Whalen. Ed is the president of the Ethics and Public Policy Center, and he directs the Ethics and Public Policy Center's program on the Constitution, the courts, and culture. He's a pretty well-known expert on constitutional law and the judicial confirmation process. And where I first learned about Ed, and I think a lot of people have, is that Ed is a pioneer in the field of legal blogging. He writes the Bench Memos blog for National Review, which is an invaluable resource for us laymen that are constantly trying to understand legal issues in the news. But in addition to that, Ed is obviously written at length for all manner of prestigious publications under the sun, in addition to National Review. Previously, Ed has been a lawyer, and he was a former law clerk to the dearly departed Supreme Court Justice Antonin Scalia. He has served in positions of responsibility in all three branches of government, not the least of which was a stint as the principal Deputy Assistant Attorney General for the Office of Legal Counsel in the Department of Justice during the first term of the Bush administration, where he advised the White House Office of Legal Counsel and all manner of people in the executive branch on important legal issues. Anyway, thanks, Ed. And last but not least, Rod Schaefer is an affiliate professor at the University of Washington School of Pharmacy. He was formerly the CEO of the Washington State Pharmacy Association for 14 years, and he has served on the Board of Trustees for the American Pharmacists Association and is past president of the National Alliance for State Pharmacy Associations. He has served on all manner of state and national health task forces in Washington and beyond. I'm staring at a list that is incredibly lengthy. Suffice to say that he is more than qualified to speak to these particular issues. And not only is he very knowledgeable about the politics and issues affecting pharmacists generally, we should be grateful to have him here because he is from Washington State himself, where this issue is happening, and he's had a front row seat to watch a lot of these developments and comment on them. So without further ado, I'd like to once again thank you all, and let's get right to it today. I'm just going to sit down over here if that's all right. We get a little cozier with everybody. All right. So just to get this off, we got a little bit of a introduction to the case from that video, but could you perhaps give us a little bit of the Cliff's Notes of the particular legal issues involved? Like what are the exact state legal issues involved or federal issues involved, and like a brief timeline about how this case sort of arose as a result?
Sure. I think we were opening up today to kind of each give a personal statement on what our role has been in the case and what it's meant to us. And so a large part of my role has been to look at the law and try to find a way to help our clients have a right of conscience. I began working in this area on this case over 10 years ago, which seems like a very long time when I think back. Like, my children have been born during this process. But it's been an incredibly exciting journey. 10 years ago, I was a younger attorney at my firm, Ellis Lee, and I started to see in the news just some occasional headlines about the Board of Pharmacy and that they were considering a rule to basically force religious providers to stock and sell Plan B. And all the headlines said that. They always referenced Plan B. That was the drug. That was the issue. So I got a call from someone who was a group of people that were attending these rulemaking hearings, and they said, could you come and help us? And so just kind of behind the scenes, we would talk and try to figure out, well, what could be done at the rulemaking hearings? In that process, I began to see headlines involving the Stormans family as well, that they had a complaint filed against them and that there was a boycott going on led by the governor of the state of Washington. Just so happened we both, Lynn and Ken and I were at a meeting, and I tend to be, it may be hard to believe, but a bit of an introvert. I don't talk to people I don't know very easily. But I just saw him, and I was just so inspired by the stand that they had taken. So I just went up and said, I'm Kristen Wagner. You don't know me, and I think the world of you. If there's ever anything that I can do to help you in your situation, please let me know. And who knew that it would be what it has become? So that's a little bit about how I got involved in this process. The Stormans were truly caught in the crosshairs of an agenda. They weren't a part of the rulemaking process. They didn't testify at any hearings. They were to be made an example of by test shoppers. In terms of the process and the legal principles at stake, when I think about the key legal principles at stake, the first thing that comes to mind is the fact that the state is basically arguing, as long as we don't include religion, we don't say we're targeting people of faith in the actual text of the law, you can't pay any attention to what we're doing in operation. So we can target people of faith. We can only prosecute Christians or Catholics who have objections to Plan B and L. We can only go after those people. But it's not discrimination, and it's not a violation of the Free Exercise Clause, as long as the law says we potentially could go after everyone. And that's a real problem if you think about it across lines, even outside of healthcare, how that will apply. So essentially, this regulation is allowing referral to occur for all kinds of reasons. Take, for example, you need to buy a particular drug, and you need 5 pills, but they have to order 10. Well, pharmacy typically may not order if they have to order in bulk. Or there's a particular compound drug you want to mix together 2 creams, and they could do it, but they don't want to take the time to do it. They'll refer you. Or they don't want to accept your insurance. Or they want to stock a different brand of the drug. You will get referred. All of those referrals are okay. But this law in operation bans religiously motivated referrals. It's the exact same conduct. The only difference is why you're engaging in it. And that's unconstitutional. Second principle that I think is important in this case is if the Ninth Circuit ruling stands, it will be the first time in America that we have forced healthcare providers to participate in the taking of human life. That's significant. That's groundbreaking. And it's frightening. Lastly, I'd just say on a personal level for me, I've litigated many cases. I was in private practice for 17 years and doing employment law and contracts and those things. But for me, most of the constitutional cases we do don't go through a trial. This went through a 12-day trial through years of discovery with 800 exhibits, 22 witnesses. You couldn't have gone any deeper than the trial court did. And the court issued over 100 pages in detailed findings. 100 pages, that's a lot for a trial court to issue. The Ninth Circuit completely disregarded those findings, which if you go back to what we lawyers know should be the way that the justice system operates, you give deference when there's a trial. You give deference to the man or woman sitting on the bench that heard that testimony and was able to look at those documents. That did not happen here. So it's very disheartening and frankly discouraging to think we are so end-related that the means doesn't matter anymore.
Rod, do you want to tell us about your particular involvement and what you witnessed here in the past decade or so?
Sure. Good afternoon. I was the executive director of the Washington State Pharmacists Association when this all began to take place. And I'll have to tell you, the fact that I'm even sitting here surprises me, because that was never what I thought was going to happen. In early 2000, Plan B was just coming out. There were lots of interest in getting that information out to women who might want to use it or have access to that. And we were invited to meetings as the pharmacy group to actually see if we could help them in that exercise to improve information and get the word out. And in Washington, we had a unique law that allowed a pharmacist, under a prescriptive protocol with a physician, to actually prescribe drugs. It was a dependent prescriptive authority. And so in this discussion with them, we decided that, well, we could actually even do more maybe. We could actually even have pharmacists who were interested, could get prescriptive authority. Women wouldn't have to go see the doctor. They could just go to the pharmacy. It would be much more accessible. And we had this great relationship with Planned Parenthood in this whole process. And we were just their biggest buddies. And then in 2005, 2004, that relationship changed. And all of a sudden, they were before the Board of Pharmacy, and they were wanting to eliminate this ability of pharmacists to refer because of a religious belief. And we supported the board in their refusal to have that happen. The board voted opposed to that twice. And then the governor finally got involved and threatened to remove board members, that she would replace them all if they didn't do the right thing. And then we began to have these task force meetings that the governor called. And it was the Pharmacy Association, it was Planned Parenthood, Northwest Women's Law Center, and the governor's office. And that was it. There were no religious groups that were there, no people who might have an interest. And we would go through, for 2 years, we went through this process of sitting down and saying, because we're trying to define how can we refer, because referral is a cornerstone of healthcare in this whole country. I don't care what part of healthcare you're in, nursing, physicians, hospitals, emergency rooms, everybody refers when they either A, don't have it, can't perform it, don't have the expertise, all those kinds of things. Pharmacy does the same thing. They have that taken away from us. So we were in this process, we were trying to define what it was that we could do. When could referral happen? And we didn't think this was, we would come to these meetings and we would go, okay, we can refer for all the things that Kristen talked about. I don't stock the drug, I don't have the expertise, I don't take your insurance plan. All those kind of business decisions, everybody at the table said yes, 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 refer, 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 because we're trying to get patient access. And then we'd say, but if I want to refer because I have a religion, no. It was just flat no. There was no discussion. It was off the table. At that point, it was off the table. And it surprised us because Oregon was kind of going through this same process at their board, and they had come to a rule that basically said pharmacists could refer based on a religious objection, but it had to be a facilitated referral, which was fine. I mean, versus you coming in and saying, can I have that? And we say, no, we don't have it. Good luck. They would say, no, I don't have that, but I'll call CVS down the street and I'll make sure they have it and let them know you're coming. Planned Parenthood, Northwest Women's Law Center, we had a letter that they wrote to the Oregon State Board of Pharmacy that said, we love this rule. It's perfect. It's just what we want. It's the access that's needed. And so we presented that to them in this process, and they literally looked at us and said, yeah, that's what we got in Oregon, but we can do better in Washington. It was a done deal. They were going to get, they wanted to eliminate this option for us to refer.
Ed, I assume you have more of a big picture perspective on this?
Well, sure. Let me start by saying that unlike Kristen and Rod, I have not been personally involved in this controversy. I've been an observer from afar for some years of this case, but also of a lot of other attacks on religious liberty in this country. A broader pattern that ought to be very disturbing, and that really presents the question whether this country is a place in which traditional religious believers will be able to live and thrive, or whether sooner rather than later we may need to look for another place to live. On the broader legal issue here, as Kristen mentioned, there's basically a divide over what it means for a law, or in this case a set of regulations, to be neutral and generally applicable, such that under the court's 1990 ruling in Employment Division v. Smith, no particular accommodation for religious beliefs is needed. What you see here is just an appalling account. Rod mentioned some of it, but I invite you to read the cert petition that ADF has submitted. The very hostile targeting of pharmacists and with religious beliefs precisely on this issue, time after time after time, just trying to make sure that, look, if you have secular reasons for not dispensing a certain drug, that's fine, but if you have religious reasons for not dispensing this drug, we're going to go after you. And I hope very much the court grants review next week. Given the current composition of the court, it's a little difficult to be too optimistic about what the court will do in the long run, but this is a battle that needs to be fought and needs to be won. In the larger picture, I see this case connected with the whole series of assaults on religious liberty. It's particularly related, I think, to what we see going on in the Little Sisters case involving the HHS mandate accommodation. It's not enough that something be readily available through ordinary market forces. It's not enough that the government has plenty of alternative means available if there are market deficiencies to provide objectionable products on its own? No. Religious believers need to be conscripted and dragooned to violate their consciences and forced to provide these services. It's as though anyone now who dares to exit his home, has his conscience nationalized, is viewed as a public utility. And the goal here, I think, really is to delegitimate traditional religious beliefs and stick it to, sharply penalize those who abide by these traditional beliefs about, for example, the dignity of unborn human life. And I think it's a very, very dangerous road we're heading down. If, for example, these regulations survive, it's pretty easy to see the next steps, not only other states adopting such regulations, but all medical school students forced to participate in abortion as a condition of getting a medical license. You could see Catholic hospitals throughout the country basically being forced to shut down. And that highlights that what we're talking about here really isn't providing services to people who need it. Because the country is not going to be better off if, say, Catholic hospitals are shut down. It really is about stigmatizing and penalizing and marginalizing anyone who dares to act out his or her conscientious beliefs. So with that, again, I hope very much that the court will fix this. One of the requests that ADF has made is for a so-called summary reversal, in which case the court would, even without granting full review, say the Ninth Circuit got it so wrong that we're going to decide that right away. Again, I'm not hopeful with this court, but it'd be wonderful to see.
I was struck by what you just said, Ed, about this attempt to delegitimize believers. What's interesting is if you go back and you look at the New York Times editorial, I believe that the day after Roe v. Wade was decided, the editorial literally something along the lines of, well, thank goodness we resolved that. We can, all agree on this and move on. And, clearly that hasn't been the case. And I think to some extent you're seeing this also with post same-sex marriage of Obergefell, where the same thing, like they are quickly moving to try and penalize people with using the force of the law as much as they can, because they don't want an open, festering cultural wound like abortion has been for 40 years. They don't want religious liberty to be this problem for enforcing a cultural consensus. So with that in mind, I was actually going to ask this anyway, but Ed brought it up, and this is for either Kristen or Ed if you want to address this. To what extent are we, stepping down the slippery slope here? I mean, you brought up the issue of Catholic hospitals. I mean, the objection here is they don't want to terminate a life, and if the government can compel the termination of a life in this instance, what's to stop them from declaring that all the Catholic hospitals in the state either have to shut down or perform abortions?
Well, it's not a slippery slope; it's a cliff. And I think the left is eager to push lots of us off that cliff. And there is no principal distinction between what they're trying to do in this case and the whole parade of horribles that is soon to come.
And specifically in terms of Washington State and ADF, in terms of Washington State, half of all hospital beds are in Catholic facilities. So this will create a healthcare crisis. The USCCB as well as the Washington State Catholic Conference have weighed in, filing an amicus brief with the Supreme Court, telling them, you're forcing us to choose between our healing ministry and our faith. And don't make us make that choice. Essentially, they're saying you won't like the result, nor will we. In fact, there were 14 amicus briefs filed at the Supreme Court urging support. At a larger level, though, I mean, this discussion about moving from chemical abortion or the week after pill to a surgical abortion and violating a conscience there, we're already falling over the cliff in some sense, and that the ACLU is suing around the nation to force Catholic hospitals to go ahead and have to do surgical abortions, and we're a party in one of those cases right now. So this is easily foreseeable as the very next step.
Okay. One thing I wanted to ask about in terms of the legal issues, this issue of access. I believe there are something like 30 pharmacies within 5 miles of the Storman's store. So, if the issue is in theory about access, as I understand it, how do they justify what they're doing?
Well, they took a number of different positions at trial. You'd knock one down and they'd try to come up with another. But what the trial court found in 100 pages of findings is that no person has ever been denied any drug in Washington state due to a religious objection. There was no evidence to that effect that was taken. In addition to that, there are 33 pharmacies that regularly stock these drugs within 5 miles of Stormins, and they regularly stock it. You can buy this drug on the grocery store shelf now. It couldn't be more widely available. So access is not an issue. Sometimes you'll hear someone say, well, what about if someone needs a different drug? Well, one, we would say that's a different case, and two, if the state is so concerned about access to a drug, then it really ought to stop all these referrals for secular reasons, right? Because if you're truly trying to increase access, the board's own survey says 10 times more pharmacies don't stock these drugs because they just don't want to for convenience and business reasons than religious. So why wouldn't you have a uniform rule that applies to everybody the same way? Well, as the trial court found, it's because your sole purpose in passing the rule was to, quote, stamp out, end quote, religious objections to Plan B. That's what this was about.
Rod, it's my understanding that you actually played a role in getting Plan B available over the counter in the state, or were on an advisory board or involved in that. Could you talk a little bit about that?
I wasn't directly involved in that. That was at the FDA. And so, I mean, we supported that as an organization. And I think just to step back about the access issue, the board did a survey about access for this particular drug, not just any drug, but this particular one. And I think that's important to note. Never was this about anything but Plan B or Ella. The State Pharmacy Association did a survey where we looked at access in the state, found no lack of access for anything. And so, again, just to reinforce, it was about being able to take away this ability to refer based on a religious objection. And I have to believe that for the most of us sitting here, that we would be very concerned about entering into a practice or believing that we were entering into a medical facility in which they left their moral compass at the door. I don't know what the next Plan B drug will be down the road. We were talking about genomics and genetic type manipulation. I don't know what that's going to be. And I certainly don't want to be in a position where I'm told that's, regardless of what they develop, that's what I have to dispense. I'm not an ottoman.
Since you were in a room with the governor and some of these other activist groups that were pushing for this, I mean, I presume that like this came up. You were saying literally the only reason why you won't go along with this is the religious objection. I mean, what did they say to that? Did they say, well, yeah, we want to punish these religious people? Is that what they said?
They didn't put it as crude as that. You know, there weren't nails and a cross in the corner, but the fact of the matter, it was true. I mean, when we got to that part of the discussion, Mark, it was just, no, we're not going to go there. That is absolutely off the table. If you refer based on a religious objection, that's going to be against the rule. That's going to be against the law. And they didn't justify it. The governor's office didn't justify it. Planned Parenthood didn't either. But that was their position. And the Board of Pharmacy didn't want to go down this road. I mean, they had rejected this twice. And then the governor stepped in and said, you know, I'll replace you.
Indeed, as I understand it, though, I invite you to correct me if I'm wrong, Rod, the pharmacists associations have long completely supported these conscience objections. And I'll note that the cert petition filed on behalf of Stormins has been supported by an amicus brief by the American Pharmacists Association and 37 other national and state pharmacy associations that call Washington's regulations a radical departure from past regulation of the pharmacy industry. So again, you need to have in mind here that what the left is doing is radically changing the terrain in a way that's just very destructive of religious liberty and very hostile to the traditional approach taken by the professional industry.
So, Ed, you're known as kind of a court watcher, as it were. What are the likely scenarios here you see, you know, as we consider this case? I mean, what's the likelihood of it being accepted? And if it is accepted, you know, what are the best and worst case scenarios here?
Well, the court, of course, now has 8 justices, which makes getting the 4 votes needed for cert a little more difficult than when there were 9 justices. I think this is a case that Justice Scalia might well have been very interested in reviewing. The court may be more hesitant now to grant cert while there are only 8 justices. So one possibility is the court just sits on this for a while. Obviously, another possibility is that it denies review, and third possibility is grant, and the fourth possibility is that that there's a summary reversal of the Ninth Circuit. Now, I think the most likely scenario is there's a grant with the case to be argued next term. Decided sometime in early 2017. Obviously, there's a danger of a 4-4 split, which would affirm the decision below, but not create any binding precedent. But at some point, the court really needs to clarify the circuit conflict on just when a law, or again, in this case, regulations, are not neutral and generally applicable, and it seems to me this case provides a good opportunity for the court to do that. And that's an issue that I think all the justices ought to be interested in sorting out.
So one of the reasons I was asked to host this panel is that I grew up in White Salmon, Washington, and Bend, Oregon, and I don't know why exactly this is. There have been some pretty rapid cultural shifts I've observed in both of those states since I was a child, and now both Oregon and Washington are hotbeds for at least 3 high-profile religious liberty cases that I'm aware of. And so I was just going to throw this out there to Kristen and Rod. Outside of the courts and sort of the outside of the courts and the legal issues immediately surrounding this, and or even the pharmacy rules in the state, is there any general level of awareness of this issue in the state? Has there been any grassroots pushback? Is there any sort of any local politicians or anything making a big deal of this? How's it playing out in the court of public opinion back in the Evergreen State?
I think to a large extent the media fanned this when it was happening. And every time that there was some report about somebody being denied access to this particular drug, it was blown up in the media, and then they would move on to, well, if the pharmacist thinks you're a drug abuser, they're not going to give you your medications, or if they think you're an HIV patient, all these kinds of horrific stories that would get the media or the public all stirred up. And then it would die. So I think the answer probably is there a lot of public attention paid to this? No, I don't think so, because life for pharmacists and basically patients hasn't changed, just for Stormans, right? That's the only place that this is playing out. Everybody else is doing always what they did before, and I think that's unfortunate, because when that level of interest by the public isn't there, lots of things can happen, and I think that's the case here.
I think, too, it underscores the point of what the Free Exercise Clause is supposed to protect. It includes protection for religious minorities. Because if the majority was able to, the majority has the political power to get the exceptions they need. That's why pharmacies can refer for all the business reasons, because they have the political power to make that happen. But when only 2% at most of pharmacists in the state have a religious objection, they don't have that kind of political power. And when you're in a state that is extreme left, like Washington State is, you don't have a majority consensus in the legislature, and you have a governor, and this is an important part. The governor started this thing with Planned Parenthood, and at one point we got about a month out from trial, and the state called us and said, the board wants to change the rule. They're going to give you facilitated referral. So, of course, we're like, what are you talking about? We've litigated this for years. Why are you caving? And they had lost on an issue. They'd sought summary judgment, so that's what it was. So we executed a stipulation. The state stipulated. That means the state agreed that the Stormans referrals do not impair access to medication, and that facilitated referrals continue in the state for all kinds of reasons. They stipulated to that. It's an uncontroverted fact. At that point, the governor heard The governor sent a letter again to the board, threatened the board again, went to the legislature, and on the day that the board voted on these final rules, the very next day, the Senate had scheduled a hearing to terminate board members who didn't vote the right way. April 12th was the day. So the amount of political pressure that was wielded here is incredible.
So getting to the politics of this a little bit, I know that the politics also directly played into the decision by the Attorney General of the state to go after Barronelle Stutzman, the florist in Washington State, who objected to, she had it's a long story, but short version is she had a customer that came to her store every day for 9 weeks, gladly served him. They were wonderful friends. He asked her to do her gay wedding. She had a religious objection to it, and then all of a sudden it blew up into a big issue. And it became sort of a political thing. In Oregon State, the Attorney General that went after the bakers in the suburbs there, he wasn't the Attorney General at the time. He's the Department of Labor, and now he's running for Attorney General. So clearly these are political issues. Has this been used in a political sense? Because I haven't heard as much about this case nationally as I have some of the other ones.
Well, in part, we haven't sought any attention on the case until just recently as we're going up to the Supreme Court. Attention didn't help. As you already heard Rod talk about, every time that fan was flamed for the Stormans family, they were subjected to additional boycotts by the governor and Planned Parenthood activists. So Planned Parenthood had an orchestrated campaign with forms and all kinds of things, getting people to try to picket and boycott. So we didn't seek that kind of attention. But it is very much a part of an orchestrated campaign, and I would say Barronelle's situation is identical. You're dealing with almost the same legislature, too. And the Attorney General there is said to be running for governor here when he gets an opportunity.
Right. Okay. Well, I will say this. So, having covered religious liberty issues as a journalist for a number of years, it hasn't produced an overabundance of hope in the last couple of years. But I honestly, at the same time, have this sense that I don't think Americans, in terms of democratic consensus, are so far down this path that they're perfectly willing to let the government run around telling everybody what to think and how they should go about discerning truth and all these other, I think, bedrock issues for free expression. So at the same time, the left clearly has this agenda to push believers out of the public square altogether. So my question here is, I guess, what do we do? I mean, do we see any sort of backlash brewing against this? Like, what's it going to take to get to a critical mass here where people understand the issues involved, understand what's at stake, and stand up and say enough?
Wow.
Ed, do you want to?
That's an easy question, I guess. I mean, and I've said this to others, and I keep saying it, is I don't understand how we got here, because we had a system that was working, that allowed everybody to live in the same space and still, adhere to their beliefs, and it was working. There were no access issues. So, to generate this whole crisis about referral and not being able to refer because of this religious thing, just, I guess, gets back to me the fact that how did we get to a place where we don't tolerate each other's beliefs? How did we get here? I mean, it's just interesting to me. You asked about the media earlier. There was, in Seattle being a very liberal place, we have lots of street fairs and those kinds of things, right? There was a petition that was going around, to get people to sign to send the Board of Pharmacy, and the brochure they had it was kind of cute, actually, but it was 4 feet coming out the end of the bed, and then there was an extra set of feet, and then it said, "Who invited the pharmacist?" And it was, I thought, well, that's kind of clever, but the fact of the matter is, it was never about access. It was never about people getting care, which it should have been. It was only about the fact that we needed to stamp out this referral for a religious belief, and it's discouraging, disheartening.
In terms of how we got here, I think the answer in part is that the left isn't content with its own freedom to do as it wishes. It certainly isn't content with the freedom of others to do as they wish. It wants validation for its views. It wants to stamp out any views that question its own. So where do we go from here? I can't claim to be optimistic. I think in part we see this series of steps that seem to proceed somewhat gradually, but the underlying logic clearly takes us to a certain place that is going to be very, very dangerous. But I think the American people may be too asleep to pay attention to where we're going. I'd love to see religious liberty battles fought out in state legislatures. I think we see in the marriage context how big business is basically allying with the left on those battles. I don't think the same alliance necessarily occurs on the abortion question. So maybe there's an opportunity there to carve out protections. Look, if those of us who believe that the unborn human being is deserving of protection, and further believe that we cannot and will not be complicit ourselves in destroying human life, are forced to a choice of either abandoning a whole set of professional opportunities or violating our consciences, this country is going to be getting to a very ugly place very quickly. I simply do not understand how folks on the left can fail to respect the conscientious objections of those who don't want to kill the unborn human beings. Now, look, I recognize that there are disputes somehow, notwithstanding the science, on the part of some as to when human life begins. Of course, I'm not sure that folks on the left have ever entirely answered that question themselves, whether it's at birth or 3 months after birth or, when you finally get the teenager out of the house. I don't know. But their inability or unwillingness to answer that question, I would hope wouldn't prevent them from respecting the consciences of those of us who have well-grounded beliefs and who are going to comply with their own consciences in following those beliefs. And if we're forced out at profession after profession, I don't know, what country do my kids grow up in? I mean very seriously, this is sort of religious persecution. Look what's happening to the Stormans. I mean, they're facing massive financial penalties. Look at some of these other clients that Kristen mentioned, all because they won't go along with the left. At some point, people are, if that threat continues, people are going to awaken and figure out, I don't know, where's the alternative? Costa Rica, New Zealand? I don't know. I've been pondering that myself, so.
Well, I think that's right, and I think that most people don't quite understand yet that these are not like some fundamental huge conflicts. What these are about a balancing test. This is about carving out very narrow exceptions for people that don't generally, affect life and commerce all that much at all, and understanding that we can live and let live and cause actually fewer problems by embracing a more tolerant solution than trying to make every issue some Manichaean, do or die decision, and creating a crisis. I think, as Rod said, I mean, it's literally an artificially created crisis to push an agenda. Well, anyway, with that, this was very enlightening thus far, and I'm sure we're not the only folks in the room that have enlightening things to say. So at this point, we were going to turn it open to questions. So if anybody in the room would like to ask questions of our panelists here, speak up, please.
Are the Stormans willing to refer? And if a pharmacist is not willing to refer, does that change the legal calculus?
The Stormans are willing to refer, and they have referred, as has our two pharmacist clients, Margot and Rhonda. In terms of a case that would involve not referring, that would be a very different case. And the issue in this case is that the state allows referral. It allows referral for secular reasons. So it has to allow referral for religious reasons because you can't treat the same conduct differently based on the religious motivation. So that's the legal principle that's at issue in this case. Someone that wouldn't refer, there may be a different legal principle that would apply in that case.
This is for Kristen and Ed. I'm curious as to what how the Ninth Circuit got around the constitutional argument, because I'm having a hard time seeing how they were able to just sort of dismiss that. I get that they dismissed the factual findings, but could you talk a little bit more about what their response was to the constitutional claim?
I'm no legal expert, but I think the answer is they're the Ninth Circuit.
Okay. Well, there were a couple different arguments that they made. Notably, they didn't even wrestle with the prime cases that we cited in our briefs. Didn't even mention those cases, so that should give you a hint. Cases that are very well known in free exercise jurisprudence on exemptions, they didn't go there at all. Instead, what they said was the regulations apply to all objections unless there's an exemption. So just think about that for a minute. I mean, that's pretty circular unless there's an exemption. The issue is, what are the exemptions and what's the real effect of the law? They didn't look at the real effect in operation. They looked at the four corners of the document. In addition, most of their decision hinges on one factual finding, which, as you know, a factual finding is something that a district court, trial court makes, not an appellate court. The state argued that the Board of Pharmacy was a complaint-driven system, that's the system they use to enforce the rule. Never mind that one of these rules has been in place for 50 years, the other had been in place for nearly 5. The only pharmacy that had ever been deemed in violation of either of those rules was the Stormans Pharmacy. So never mind that. Never mind that the only pharmacy they're going after is religious pharmacies. What the state argued and the Ninth Circuit said was, well, there have been no complaints filed against any other pharmacies, so the board doesn't need to go after anyone else. And never mind that Planned Parenthood was the one that is now the enforcer of the rule. I'll also just point out real quick and then hand it over to Ed, that not only was the district court's finding, but it was supported by overwhelming evidence, which Rod thankfully helped us with uncover. The Board of Pharmacy does inspections every year. They inspect and they look for every violation of this particular regulation except the one at issue against the Stormans. They test shop pharmacies to make sure they're in compliance. They do educational seminars. They do all kinds of things to enforce their rules. So that factual finding was not only found by the district court, but supported by overwhelming evidence. Ninth Circuit didn't talk about that.
Just a couple brief comments. First, again, there's been this split among the circuit courts as to how to determine whether a law or regulation is neutral or generally applicable. The Ninth Circuit took an extreme version of one side of that split. The judge who authored the opinion, I believe is it Susan Graber? Is that the first name right? You can speak to this better than I can, Kristen, but I believe she had received an award, years ago before this case from one of the pro-abortion organizations that was very involved here. That's, I'm not saying she wouldn't have reached the same result if she hadn't received that award, but I think it's reflective of the ideology of the Ninth Circuit, packed heavily with Clinton and Obama nominees, and Carter still.
I don't know. I find this particular instance, I see this again and again on these cultural issues and the religious liberty battles, where the courts, liberal courts, do this weird thing where they take this conception or norm that they think should exist and issue these rulings that right around this as if this norm or ideal that they want does exist and is codified in law and enforce it as such when there's no such thing there to begin with. And that's kind of exactly what I think is happening here. It's they would like to believe that like this is set in stone, that this is constitutionally permissible. So it's like if they just act like it's permissible long enough, it will become permissible. And that's actually kind of happened, I think, in a lot of jurisprudence.
Hi, I'm Patrick Gregory with Bloomberg BNA. Mr. Whelan, could you break down a little more this circuit split issue as far as what the circuits have held on what's generally applicable or not?
Well, I'll be relying on ADF's brief here. Kristen can probably speak better to this than I can. I know that the Third Circuit years ago, in an opinion by then Judge Alito, took I think a fairly common sense view of what it means when a law or regulation is not neutral or generally applicable. But the whole question of targeting arises in different contexts. And Kristen, I invite you to flesh this out better than I can.
Well, there are basically three main areas of circuit conflicts. The first conflict is on categorical exemptions and individual. I'll mush two of them together: categorical and individualized exemptions. Meaning, if you're exempting conduct out, and you exempt it out categorically, then in order to go after religious objectors, you need to demonstrate that the exemptions that you've created serve a different purpose, and that the purpose that you have for exempting those wouldn't also apply to religious. Because otherwise the state's making a value judgment that secular motivated conduct is more important than religious. A second area of conflict is over the treatment of individualized exemptions. The court, and particularly the Third Circuit, Justice Alito, when he was on the Third Circuit, has a series of cases, and there are other circuits as well, that talk about if you're going to create this open category that allows the government to look at the relevant reasons for why you did what you did, then you have to allow people to do that same conduct for religious reasons. Because again, you're inviting the court to use its discretion and individual judgment to say, religion not important, money important. And that's what you see happening. So if you're going to allow an individual exemption, then you need to look at strict scrutiny. It's not generally applicable. There's a circuit conflict on how those are interpreted as well. And then lastly, there's a circuit conflict on historical background. I should say there's one more: selective enforcement, which is can you go after, even though a law may say that it applies this way, Lukumi, which is a free exercise case, says you got to look at how things really operate on the ground. There's a circuit split over what that means and what you should consider. And lastly, there's a circuit split over historical background. So we have a whole lot of dirt, frankly, on Planned Parenthood, Northwest Women's Law Center, and the state and what they did. That's the beauty of going to trial, is you had years to go through discovery and depositions. We got some great emails, even where the board is saying things like, wouldn't it be better just to go after the religious exemptors? Wouldn't it, things like that. Openly hostile statements. Let's prosecute to the fullest extent of the law. Even at trial, one of the chair of the board suggested that it's appropriate for conscientious objectors to have to go to Canada or go to jail. And this is the kind of stuff we've uncovered. The circuits are split on what you do with that kind of evidence. Do you just look at what the law says, or are you going to look at this historical background to determine targeting? So those are the main areas. I will say one more thing on that, which I found curious. I didn't even know this when we started this petition. In the last 25 years, since Employment Division versus Smith, the Ninth Circuit has not upheld a free exercise claim, with the exception of one case which was reversed. So that tells you what's coming out of the Ninth Circuit on the free exercise.
This is a general question that I've always thought about. It comes up in the wedding florist cases and the wedding cake cases. I think it comes up in the same-sex marriage license cases, and everyone has referred to it here, which is when the marketplace is readily providing something. We think about the rights of the religious minority that doesn't want to provide that. Well, what if you have the reverse scenario where the community coalesces around a religious viewpoint, and you have no florist who will provide flowers at a same-sex ceremony, or no bakers that will provide the wedding cake, or no pharmacists that will provide Plan B. So I guess the question in legal terms is, how do we think about the First Amendment protection for religious freedom when we have the opposite context? And is that a question worth thinking about, or does it make sense just to think about the world in which we live right now?
Well, it's an interesting but unfortunately far too hypothetical question, which doesn't mean it's not worth thinking seriously about. I think that if you apply the framework of the Religious Freedom Restoration Act that tries to make sure we accommodate religious liberty, there is the exception where the government can show a compelling interest and can show that it's using the least restrictive means. So the market unavailability, I think, could well be a significant factor under that test. Now, you know, in reality, I don't think there's anywhere in the country that you're going to have market providers not racing to provide services to willing buyers. So I do think that the question is hypothetical insofar as it raises a potential danger. But again, by that I don't mean at all to disparage the role of the question in sorting out the proper analysis.
Almost all of the religious freedom laws and other things that have been cropping up as a result of trying to address these problems involve balancing tests, which is to say you can refuse a customer, but that doesn't mean you're like some blanket untouchable once you've done that. You know, more often than not, you have to go to the court, and you know, if someone brings a claim against you, you have to go to the court and prove that your exercise of religion has been unduly burdened. I see Kristen nodding carefully to make sure that I get this right. And so again, it's not, you know, the goal here is not to give people a license to say, well, I believe this, so I get to do it. You know, it's not, you know, some self-actualizing thing. You know, it has to still be balanced against, you know, the general interest of the community in these cases.
I think, too, the fact, you know, in none of these cases that are going on right now, whether you look at the wedding industry or you look at the life context, the economic incentive is so strong. The polarizing effect on a person for having to stand up for their religious convictions is a big discouragement. And I mean, you really have to know what you believe to be willing to take this fight on. So I think that, you know, your suggestion that could happen, I find that really difficult to believe. And even in those tests where we engage in the balancing, the First Amendment's there for a reason. So there's no case, at least that I'm aware of, in the United States, in the wedding context, where there's not an expressive component in that litigation. We're forcing people to create art. We're forcing them to promote messages. We're forcing them to take human life. The First Amendment means something. And so in the balancing act, I think we win. Seems pretty clear to me.
I also just want to add about the hypothetical component. I agree with Ed completely that there's a worthy question and worth considering because, you know, who knows what may happen in the future. Having said that, as for the actual, you know, what's going on the ground, the people making these stands are generally experiencing the exact, you know, opposite of communities coalescing around them. For instance, the case in the suburbs of Portland, Oregon, where there was a Christian baker that refused a gay wedding cake, immediately there was unbelievable protests in the community. That's those people's right. Within like 6 months, their bakery had been shut down effectively by the community because nobody was willing to go there. And then a year after that, the State Department of Labor came in with a 6-figure fine after their bakery had been shuttered. Why? You know, I mean, if the goal is to not have these people in your community, you know, then the community has its own ways of dealing with that. And so, you know, as far as the hypotheticals go, that's generally the state of play. Okay. Anyone else?
I have a question for Mr. Schaefer. I had handled another pharmacist case about a decade or so ago now, and one of the features in that case was that the governor of Illinois had basically denigrated the role of pharmacy. In order to justify the rule, he basically acted as if pharmacists were no more than mere clerks. As a matter of fact, actually arguing that they were not covered as healthcare professionals at all under the state conscience law. Is that something that has also been a feature in Washington State? And have you seen a response, even from people who otherwise might have been in the pharmacy industry comfortable with the rule, looking at this and saying, you're treating me as if I'm not a professional and I don't have sort of a professional role here on referrals? Right.
First of all, I'll address it from a Washington standpoint. Pharmacists have been covered in the statutes and the rules about conscience referral. Clearly, they're in there. And I didn't hear anybody in the discussion suggest that pharmacists were not healthcare professionals, that they didn't have a very important role to play. I think that sometimes, you know, we hear that from folks who say, you know, just who probably don't understand the healthcare system and the checks and balances that have to be in place, because they'll say, well, you don't need to figure this out because my doctor wrote it and he's right. That's a very narrow view of the professions and how they interact, because pharmacists catch a lot of mistakes that happen, and they're not necessarily bad mistakes, or they're not going to kill everybody every time, but they're important, and that's a check and balance that happens. I think you begin to worry, though, when people start to say, but you can't use your moral compass in this decision, or there may be ethical questions that you're going to be concerned about, and you just have to follow what the doctor wrote. That's very concerning to us, because we're not Ottomans. You don't put $1 in and push the button and you get a pill. Even though that's what it looks like sometimes, because they're very busy behind that counter and they're trying to do all these things. There's a lot of stuff that goes on in the filling of that prescription. So I think by and large we're starting to see pharmacists actually role increased because of trying to improve access to health care, and realizing that these are the most knowledgeable healthcare professionals that are available to everybody, and they're on every corner. We just need to encourage them. But yeah, it's a concern when you have these kinds of things that come up.
Okay. This question for probably Ed or Kristen. In an optimistic scenario, could you sketch very briefly what say a 5-3 opinion in your favor would look like? Is something that just palatable enough that you could actually get a Kennedy or a Breyer or both on board? I mean, what would that, and it's a very legal question, but what would that look like? What would they be holding were the best case scenario to happen, and you actually prevail even with, 5-3, even with an 8-person court?
Well, I think a threshold question would be what standard applies to reviewing these regulations. So I actually think that Stormans and the 2 individual pharmacists, women by the way, win under either standard. But the court would have to decide that, and I think a good result would be to recognize on the issues that Kristen identified before, that a law or regulation is not neutral and generally applicable when it allows for lots of secular exemptions, when it's enforced in a discriminatory way, and so on. And the bottom line answer to the case would be that the Stormans and the 2 individual pharmacists have a free exercise right to engage in these referrals for conscience.
We need clarity in the free exercise area on what exemptions mean and how they apply. And so, my dream world is we get a decision that gives that clarity and basically says, if you're going to allow it for this group, you do need to allow it for this group. And you don't just look at what the government says, you look at what the government does. That would be progress.
Okay, well, thank you. Just one final thing before we left. I wanted to bring up Greg Storman up here, and talk with him a little bit. One of the things I've sort of found as a journalist, which is that you don't even necessarily have to, especially when you're covering laws and or actions by government, the thing that very often gets lost is that there's a human cost to everything. I mean, even if you don't agree with something that's being done, or if you do agree with it, there are obviously trade-offs, and those affect actual humans. So I thought that'd be a good idea to get Greg up here and talk with him a little bit. So first off, it's my understanding that yourself and the pharmacists involved have been involved in as pharmacists for 60 years? Is that?
Yes, not quite that long, but yes.
Okay. And can you just tell me a little bit about how you ended up involved, and how you became a pharmacist, what you find meaningful about the job, and
I'm the owner, not the pharmacist.
Oh, sorry.
But how this happened was, and by the way, our business goes back to 1944 when my grandpa Ralph Stormans opened up his first store, and since then we've been in business for 4 generations. We've been in business, and 4 generations have worked for our business, and we're just grateful to be part of a business that operates in a small town where we take care of our neighbors, And our pharmacy is part of that. It's important to us to deliver health care and treat and have our neighbors and our customers as part of our community. When my brother received a call, and a customer had inquired about the Plan B medication and wanted to know whether we stocked the drug. And my brother said, I'll find out and call you back, which he did, and told the customer, no, we don't stock that drug. Soon after that, as was discussed earlier, a number of test shoppers came in and also requested the drug. And at that point, my brother and the rest of our family sat down and said, okay, well, something's going on here. Let's talk about it. We affirmed what we'd always believed, and that's in our pharmacy, we're about healthcare, helping other people. We're about life-saving drugs, dispensing life-giving drugs, but we would never dispense a drug that would take a life. We would never dispense a drug that would result in an abortion. And that's where it all started.
Prior to this, did you ever envision there would be some circumstance where, owning a grocery store and pharmacy, that your religious beliefs would come into conflict with that?
I never believed that we would be targeted or attacked in the way we were. We live in a small community, a community where our friends and neighbors and relatives all shop and work together. It's not something we ever saw coming at us, and when it did, it was a strong attack. We lost 30% of our business initially, and we've struggled for 10 years. And God willing, with a lot of His help and our hard work, we've stayed in business, even though it's been a extreme financial burden. But we know we're doing the right thing. And at the end of the day, that's what matters. That's how we win. We do the right thing. We stand by our employees who were targets in this as well. Many times I received calls because I'm the HR person and the operations person. And I would receive a call from receive a call from an employee, and they would say, I can't make my rent payment this week, because we had to cut wages, we had to cut hours, we had to downsize, we had to reorganize our business 5 times in 10 years. And that was very difficult on the staff. It was hard enough for us as owners to be targeted from a religious standpoint and be told you have to do what we want you to do or else you're going to lose your business. But the other part of it, and the part that no one here in the room sees, is the impact it has on our staff. And that was very difficult. And I'm proud to say that we never had to lay off one person. We worked hard to keep our family together in our business, and that's all part of our story as well.
Can you just talk a little bit about the response from the community? More, I know you have mentioned a little, but you said your business dropped off a little bit initially, and I know there have been protests and stuff. I mean, have those protests really been genuinely from within the community, or have they been from interlopers outside, or what's it been like?
I would say it's been both. Over the past 10 years, we certainly have been gratified by the fact that our business has returned for the most part. We, as I mentioned, engaged in continual reorganization of our company in order to stay in business. I think that, I'm sorry, what was the second part of your question?
Oh, I just was wondering, like, to what extent you've sort of moved beyond this in your own community, and to what extent the threats are from within and without.
So we still have the issue that's unresolved, and that's one that hopefully the Supreme Court will take up. I mean, we're very hopeful that they will take this case. I understand the composition of the court and those issues. Most of what you heard today that's legalese and all that's Kristen's side, and she's done a tremendous job for us with her team. We still battle what's important to us in our business is continuing to do the one thing that we believe is right, which every American should be very, very concerned about because of this case, and that is take our faith to work. We take our faith to work, and we engage in our morals and our beliefs in a way that we believe our faith informs us to behave. So we make decisions about whether to sell a drug. We say, no, we can't do that. We make other decisions as well. That's the biggest thing to us. That's what we have to do is allow our faith to inform us. What's our business going to look like? How is it going to run? What decisions are we going to make? This decision that will be made at the Supreme Court or not is about religious liberty. It's about the government targeting individuals because of their faith. That has more to do with our right of religious expression, not just whether we sell a drug or not.
Okay. Well, thank you very much. I just wanted to thank you on behalf of a lot of us here, because I think that even though we're not going through the struggle personally, we recognize what's at stake, and we really appreciate the fact that somebody has to stand up and be the person that follows through and hopefully gets the court to do the right thing.
Thank you for having me.
Well, thank you all for attending. Thank you, Greg, so much for sharing part of your story and being here with us today. This is an honor to have you here, and for someone who's been in the thick of it, as you have for the last decade, not many of us will ever have that experience. So thank you for sharing your story today. We really appreciate that. Thank you, Mark, for doing a great job as moderator. Thank you, Kristen. Thank you, Ed. Thank you, Rod. Thank all of you for being here. And if you haven't gotten anything to eat, please feel free to do so, and be on the lookout for future similar events. Thank you so much.